Hey, good afternoon, you guys. Tara Winslow here with Winslow Real Estate in Atlanta, Georgia. Thanks so much for joining us. I'm going to bring my good friend Sarah Watchko on in just a minute. I wanted to give you some info on her before give her a little introduction before we bring her into the meeting. Sarah is with Hill and Watchko at an estate and elder law firm out of Roswell, Georgia. She's been in estate planning for over 15 years, and she is one of a few of certified elder law attorneys by the National Elder Law Foundation. So I'm excited to hear more from her. She was offered a full merit scholarship to Wake Forest University in North Carolina and graduated from Wake in 2008. She's passionate about this. So hang on, I'm going to bring her on just one second. Thanks for joining us. Yeah, I'm excited to have you here and talk to you about more of estate planning in regards to real estate. I know you and me have talked about my dad, and he passed away last year, just for anybody out there listening. And I had an aunt pass away recently as well. And a lot of that, quite frankly, her will was not written well at all. And it's continued on with our family, cleaning up a little bit of a mess, and it wasn't clear. And so I'm hoping to help someone out there with your expertise on how they can guide either their parents or themselves a little bit better with this. So just start with the basics. What is
Sure,
an
absolutely.
estate
Yeah,
plan?
it can create a lot of, not just a lot of headache, but a lot of heartache. It can strain relationships when people don't have things in order, and then, the worst happens. So, can be really life-changing to do good planning. Essentially, a will is a legal document that dictates who receives your assets when you pass away. And there are extremely technical requirements, legal requirements that the document has to meet. The words that are used, the signatures and how they appear, whether there is a notary public or not. And something that surprises a lot of folks we're talking to is that even if you do have a will, it does have to go through a legal process called probate. So it's not like someone passes away and automatically their loved ones can run out and sell their property. There's some additional delays and hoops that we have to jump through in order to make that happen.
Right. I've been familiar with that with my
Mm-hmm.
clients having to wait and go through probate, and we're
Mm-hmm.
having to have it go through probate with my. And I wanted to say, for the people who are live, feel free to comment, to ask any questions. We're also going to do a recording. So if you hear the recording, feel free to reach out to us via email or comment below in our Instagram
Certainly.
when we post this. So I know this isn't a passion of yours. So what if someone said, what is the one thing I should do today to get my affairs
Mhm.
together so that I protect my family? Would you have one
Yeah, I mean the
recommendation to
the
start
will
with?
the will is part of we call it a package in our office. It's part of a package it's a no-brainer. It's you've got to have it. We're handling several estates right now where the person who passed away didn't have a will. And because of the requirements under the law, we're having to not only go through the process of having someone appointed who can sell the house, but even the sale has to be approved by a court. So you have to file a petition after you go under contract with all of the details. And then a court has to approve that. And a lot of these probate courts are very overwhelmed and they move very slowly. So that can definitely be an issue with closing. You're not going to get to close in 30 days under that scenario. So that's just one reason having a will is an absolute no-brainer. And the two documents that go along with that are power of attorney and healthcare directive. And related to real estate, the power of attorney would allow someone to be able to sell or manage your property if you were alive but incapacitated, if there was an illness or an accident and a mortgage needed to be dealt with, a home needed to be dealt with. Having a will doesn't keep it out of probate. There are a couple different mechanisms for that, and I can certainly talk about that next if you'd like.
Yeah, that's great, because I see a
Yeah.
question pop up about that. Does it have to
Yeah.
out of probate?
Probate's kind of been seen as a four-letter word, and it's not always that bad, but it is a delay, and it is something that some folks are inclined to avoid. And there are scenarios where it can be more than just a headache or a little bit of delay, just depending on a number of factors. So we use a living trust, a revocable living trust, really as the primary tool to avoid probate. Another mechanism that you probably see all the time in your work is if you've got two owners on a deed, two or more really, owners on a piece of property named in the deed, and the deed includes the language joint with right of survivorship. I think especially most married couples kind of assume that that's there, and often it is. And if my deed says that Sarah and Jeff own it jointly with right of survivorship, and Jeff passes, it vests automatically in me. We don't have to go through probate. But it has to have those words in the deed. And especially older deeds are sometimes missing those. We always check. So that's one mechanism to avoid probate. Otherwise, if it's passing under a will, then it will have to go through the probate process. And the trust is the device we use to avoid that.
Okay. Yeah, that's great. And thinking about different life transitions, we think about life transitions in real estate, and there are life transitions that people go through all the time where it would prompt them to think about getting an estate together. Can you tell us a little bit, a couple of those
It's interesting too, because
transitions?
in our office, these are where we have our kind of buckets of clients. We've got the bucket where they're, maybe newly married and they've had a baby, and that's like the first thing that really triggers, or even just getting married or having a long-term partner. That's the first thing that really triggers these thoughts like, oh goodness, well, I want to take care of this person or these people. What happens? So we see a lot of that. And then the next transition is typically kids getting into their 20s. So, last time I did my will, my kids were 6 and 8, and Uncle Will was their guardian and trustee. And now they're 27 and 29, and we don't need that anymore. So it's just kind of a natural progression. Retirement is one. And then really post-retirement, throughout the aging process, if there's a health condition, if there's a cognitive condition, cognitive decline being experienced, unfortunately, we see a lot of people who it's just not on their radar. So these things happen in time, and years go by, and then they're saying we need to make these changes. And if someone doesn't have the cognitive ability to do that, then we're in a tough place. So it really does kind of correspond with those major life changes and transitions, like growing family, retirement, health issues. Someone asked, does a revocable trust have to be set up before the person passes away? And it does. And that's a real big distinction. So when we're using a living trust, there's a trust document that's prepared, and then actually a new deed. So the owner of your home becomes your trust. You have not given any authority. It doesn't impact your mortgage. It doesn't impact taxes. It's just a technical titling issue that we need it to be titled not in your name, but in the name of your trust before you pass away.
Yeah, that's good information. A couple questions are going through my mind. Thank you for answering. People who are sending in questions, keep them coming, you guys. One of the things that I had on my mind is, and I know that the value that you bring as a professional, and making sure that all the loose ends are tied up, and really going deep in someone's family and how things need to work, things do happen, because we know that will happen. What would you say to someone who said, I'm going to go online and do an online
it's such a common question
plan?
And I think it makes practical sense that people would want to do whatever the best, most efficient option is, if it's sufficient. Unfortunately, and it's not to say that can't work, but we see a lot of problems. Start with the document itself. We're very, very obsessed with what words go into our legal documents. We've spent a long time. We've seen a lot of, things unfortunate things happen. So there's, the words matter. It's not like, I pull it off the shelf and that's good. Very state specific. Another challenge is, if you're the legalese, for better or worse, is hard to interpret. So you may be signing something that you don't truly understand what you're signing and could impact your decision making. The execution, the signing of the document is really important, and kind of easy to mess up. So we've seen that be an issue in the past. And then I think the other thing that you pointed out is that, when we talk about estate planning, it's more than just the documents. They're a part of it, and they're a really important part of it. But we're talking about beneficiary designations and asset titling, and really digging deep into getting to know a family. There may be risks that you don't realize are there because of a certain fact pattern. There may be options that you didn't know existed and wouldn't have clicked yes on LegalZoom unless you really understood what that meant. So I think we can definitely provide value, far beyond just the words on a piece of paper.
Absolutely. I had some friends whose parent passed away, and there were two siblings, and they thought they had the will together, and the will mentioned both beneficiaries, but they put them in order. So the oldest child was the executor, and owned everything in the will, and the sibling wasn't mentioned. They were a friend, and they actually weren't then part of the will. This was also in a different state. So to me, that, it's so detailed. It seems so detailed to me, to make sure that you catch both of the siblings. That's kind of a mess if one sibling gets left out when the parent
it's a good
didn't mean for that to happen.
of knowing what the person wanted. They knew what they wanted, but just didn't have the technical expertise to understand how to word that properly.
Right.
Right. If someone has property in more than one state, reading a question, does the will need to be written for both states? So a will would technically cover any property you own in any state in the U.S. But if you pass away and you own property in other states, then your executor has to go through some form of probate in each state. So that's kind of a red flag item where if we're meeting with a family and talking about options, we might say, you might want to spend a little more time thinking about this other trust option, or any other options that are out there for the purpose of avoiding probate, because your loved ones wouldn't just have to do it in one state, they'd have to do it in several.
Okay, great. Let me just look. I have a list of questions over here. You've talked about trust. So there's a will, and then there's a trust, and the will is part of the trust.
I think of them, and when I describe them as think of them as two different mechanisms that accomplish the same goal in different ways. A will says who gets your stuff when you pass away. And a trust also says who gets your stuff when you pass away. They're two different legal documents. It's in how they function, because a trust, you're actually putting assets in the trust. Like, the trust is now the owner. So the trust doesn't die. It continues on. It's like a bucket. While I'm alive, I'm putting my assets in this bucket. And then when I pass away, there's someone named who can continue managing those assets after my passing. Versus if I have a will, assets are in my individual name, and you have to go through the probate process in order to technically prove the will, because I didn't transfer assets while I was alive. So they really they run parallel. And the tricky thing about trust planning, you might ask, well, why doesn't everyone just do a trust? Well, the tricky thing about trust planning is it can feel more complicated, because you actually have to transfer assets to it now. So if I create a trust, I have to have a new deed prepared, and I want to get all my financial accounts titled properly in the name of the trust, or naming beneficiaries. So a little more legwork at this point to make sure everything's kind of as nicely tied up as possible.
Yeah. And you have those old 401ks, sitting there, and you may forget, and then you may not remember a different beneficiary, before you get married, or after you have children, or something like that.
Someone asked, can we bring our families' wills and trusts in for review? Yeah, absolutely. I'm sure because of our geographical location and just the, the aging population in the United States and the world, we have so many families that are moving here from out of state, often to be with loved ones, to be closer to family. And so they'll come in and they'll have their estate planning binder or folder that they finished in another state. And it does make sense. It's not absolutely required. It's our opinion that they should be updated to be in accordance with Georgia law. But it can just be updates. It's not like you have to absolutely positively redo everything. So that's a scenario where we're reviewing documents that already exist. Or if someone just wants to confirm, we prepared these, we signed these 10 years ago. These are still our wishes, but we want to make sure all our I's are dotted and T's are crossed. We do a good bit of that too.
Mm-hmm. And the healthcare directives, they're part of
they're part
will
of
and estate.
again the package, as we call it. It's not a technical term. It's the same idea as a power of attorney. If I'm not able to communicate decisions for myself, if I'm in an accident, if I have an illness, I'm not able to communicate what I want. First of all, who's going to communicate that for me? So, for example, mine says my husband Jeff, and if he's not capable or they can't track him down, my mother is the backup person. And then you have the option to say what kind of treatment you would want. So mine says, if I'm in a permanent state of permanent unconsciousness, I wouldn't want to be on life support for years if they couldn't do anything about it, or terminal condition, and you can put preferences in for that sort of scenario as well.
Yeah, I remember that became a pretty big deal when my dad was, we had a process of medical issues prior to his passing away. And I remember we needed to make sure all that was in order and who's on there. And I had to talk to Social Security. And, if you don't have those documents, they can't, they'll say, no, we cannot do that. You cannot take over, control of whatever needs to be taken over or make that decision. I mean, just something simple like that that you don't think about. So for my network, many of us are in that sandwich generation, right? That I'm sure you're familiar with, and our parents are having illnesses and things like that. So for that reason alone, I highly recommend just getting that stuff done at least, right?
It's really, truly a nightmare if someone is incapacitated and you don't have that power of attorney, you don't have that healthcare directive. And unfortunately, for the average person, it's like the will, where the technicalities, the words in the document are extremely important. The detail to which we define the authority of the person, we call it the agent who's acting for you. It's not so easy as I can just go over to Office Depot and be confident that this thing's going to work properly. We find updating them. There was a big change in the power of attorney law in Georgia in 2018 as well. So with that, we've got new language that we add in. So it's just a type of thing that you want to stay on top of. It's so simple to do and so complicated if you don't. It's just that people don't realize that, because why would you until it happens?
It really is. And, if you're dealing with parents that are ill or, just getting older and they're in the hospital, and when something like that happens, like with my dad being in the hospital, we brought in hospice, and the hospital had to release him to hospice, and one of us had to sign for the release, and it could only be the person that was allowed to do that. And just imagine if I wasn't on there, it really can become disastrous and more stressful at a time that's already stressful. I'm a huge getting all this done, so, as you can tell. Is there anything else, any other questions or anything that you think might be helpful to people who are listening or listening to the recording that you would recommend?
It's really just the basic message of don't wait don't wait too long, especially if there's a circumstance in your life, whether it's just typical aging or an illness, or a diagnosis. it's something that people find challenging to talk about, but I think you said it perfectly where, you know, the scenario is what it is. Let's do whatever we can. Let's take control of one of the few things we actually have control of, which is, okay, what is this going to look like? There was a great scene in the show This Is Us at the towards the end of the series where the character, the mother, was diagnosed with Alzheimer's disease. And while she could, she first of all did all of this and set everything up. And then she sat around with her family and had this beautiful conversation. And she told them what she did and why she did it and who was in charge. So when things developed, there were no surprises. Everyone knew that Kate was in charge of this and someone else was in charge of this. And that can really, you know, negatively impact relationships when there are, you know, when people aren't on the same page. So I think being open about it and just addressing it is really, really important.
Yeah. So it looks like we have another question. I have parents/in-laws which live outside of Georgia. When they pass away, is there anything we need to know about their trust being in a different state
Yeah, there's a
than
lot,
which we
I mean, a
live?
lot of similarities state to state and how wills and trusts are administered, and there are significant differences as well. So typically the planning, well, I should say always, the planning is going to be done based on the state where they live. And we see this a lot where you can seek counsel, you can develop hopefully a relationship with attorney in their jurisdiction, even though you live here, that can provide guidance and kind of how things work as it relates to the law of the state that they're in.
Awesome. That's great. Let's see. There's so many different areas that get talked to, you know, talk about.
I know one that comes up a lot in the aging context is, should I just quit claim my house to my adult son or my adult daughter or my kids? And typically people are either thinking, well, that'll just make it easier when I pass, or maybe they're worried about, you know, oh, if I have to go in a nursing home and I'm going to lose the home. And often when we're having these conversations, you know, the answer is not an absolute no. It's going to depend on every individual set of circumstances. But what people might not realize is there can be tax downsides, several tax downsides as it relates to capital gains tax in transferring your home to an adult child. And you can lose your homestead exemption because now the owner doesn't live in the home as their primary residence. And some of our metro counties have the additional senior exemption. So that can mean big dollars year over year. And then the other point we want to address is, okay, well then what if, you know, God forbid you put it in the name of your son and something happens to your son, there's a creditor issue or he gets divorced or he passes away and then it goes to his wife or something like that. So a lot of nuances to think through. And again, not to say that it's always a bad idea, but something that people may not realize the consequences of doing that.
Yeah, that's great. That's a great, yeah. One other thing I was thinking about from a financial perspective, when you're going through putting someone's estate together, you all talk about the different, for instance, like a inherited IRA and different ways that their money is distributed. And it's also a great way to make sure that if someone does pass away or when they pass away, is this really the best scenario from a tax perspective? Where if you're prepping for this down the road, you might be able to make that change prior to one's passing versus finding out and then you're like, oh wow, you know, this was set up wrong financially because we didn't do anything.
Yeah, absolutely. Those are kind of the hidden, you know, the hidden mines that folks might not be aware of. Certainly significant number of complicated tax rules, regulations, laws as it relates to retirement accounts. It's, you know, a common scenario is if I have minor children and I'm setting up a trust for them because they can't manage assets if I pass away. But, you know, most young people, their net worth outside their home is their retirement account. So having that trust drafted properly so it doesn't blow up all of the tax savings otherwise found, by virtue of the retirement account can be an extremely big deal. And then like with the capital gains and the sale of the home, just dealing with real estate and preserving all of the tax benefits of inheriting real property or appreciated assets versus receiving during a gift. We don't have technically what you'd call tax attorneys in our office. So there's a lot of tax law that kind of runs parallel or overlaps with what we do that we're certainly very familiar with. And then we work with CPAs often in terms of actual tax filing requirements and that sort of thing, or just in terms of more complicated planning, kind of getting them on board and making sure everything is in line.
And with my clients who have multiple investment properties, those should definitely all be in the trust.
That's a good strategy, especially if they are out of state, because it's going to make the mechanisms easier. We often use limited liability companies or similar entities, LLCs, for second properties, and that often relates to liability protection. So if I've got a VRBO rental and someone is injured on my property and they sue the owner, well, I don't want the owner to be me. I don't want my personal assets, my other personal assets exposed. So if I can create an LLC that's the owner, then only the LLC asset is at risk. There can be some limitations to that. If you have a mortgage on the property, depending on the lender, that may not be an option. And of course, umbrella insurance and all of your, insurance policies are another good backstop.
Right. Awesome. Okay. Well, I think we have all the questions answered for today, and I really appreciate your time.
Very
and thank you.
Lucky to have you as a resource in our firm as well.
Thank you. And I would love to. I think we're going to get some really great more questions coming. So who knows? Maybe we'll be back on Instagram again.
Sounds good. You're welcome.
All right. Thanks, Sarah. Have a great day. Take care.